We'll call to order the Board of Zoning Appeals. Would you please stand for the pledge? Keith, would you lead us in the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please remain standing for a moment of silence. Thank you. Call the roll, please.
Keith Bratcher.
Here.
Joe Crowell.
Here.
Jerry Sartain. Joe Machado. Michael Rather. Jared Barrett.
Here.
Lane Cantrell.
Present.
Do have a quorum, sir, and Jared Barrett would be the alternate voting, and Joe Machado.
Okay, Jared, you'll be the alternate today. You have the minutes of the last meeting before you. Are there any changes or additions to the minutes?
Mr. Chairman, I make a motion that the minutes be approved as presented.
We have a motion to be approved. Do we have a second? All those in favor say aye. Those opposed, like sign. The minutes are approved. The first item of business we have is a request by the Almaville Market. They are requesting a variance relief to reduce the front yard setback. What do you have on that?
Cantrell. Application 2013-005 is a request for variance relief to reduce the front yard setback to 18 feet for a property located in the commercial neighborhood zoning district. The property is located at 7586 Almaville Road. It is known as the Almaville Market, and the site acreage is 1.60 acres, and again, it's in the commercial neighborhood zone, and the commercial neighborhood zone only requires a minimum of 10,000 square feet. This has 1.6 acres. So the applicant would like to place an addition on the front facade of the existing business, 12 by 30, and it will encroach into the front yard setback, which is 30 feet. And the existing structure right now is right at the 30-foot line, and you can see the gas canopy is almost within a couple feet of the front property line from Almaville Road. And staff has considered the variance criteria in the zoning ordinance and found that this application does not meet all of the criteria for variance approval. There are no special conditions. There's ample room to construct the addition on different sides of the structure itself. And staff met with the applicant and discussed some concerns that we had with the site as it is already developed, the flow of traffic and how that would be impacted by the proposed addition. We thought that it might have been premature and that she could contact an engineer and see if they could bring the site better into compliance and construct the addition on another, the north orientation of the building. So staff recommends denial, and I'll just go through some of the photos with you. This is the existing structure, and you can see the seating area. That's approximately where the addition will be constructed. You can see the gas canopy on the site. And in relation to Almaville Road. And just more photos of the site. This is the area to the north of the property that's under the same ownership. Residential uses across the street. Again, another shot of the front elevation of the structure. And this is the side elevation to the south, and then this is the structure to the west. And just those were shots of the front elevation where the proposed addition. And what it is they just want to provide a seating area for people who are would like to eat at the restaurant. They serve food at the Almaville Market. And this is a rough site plan showing the proposed addition, and it will be located, if this is approved, 18 feet off of Almaville Road. And we posted the sign on the property. We've received no phone calls on this particular application, and that concludes our presentation.
Thank you. Once we've received a report from our staff, we'll ask those of you who have a request before the board to come to the podium. The acoustics in here are not real good, so please speak into the microphone. And please keep your comments strictly to what we're dealing with, the subject matter. And we may have to limit some of those if we get some long drawn out comments coming before us. Do we have anyone representing the market here? If you'll come around, please. If you'll give us your name and any additional information you'd like to share with the board.
Lisa Cahoon. I'm the owner of the property.
Is that all? Okay. Do we have any questions? Well, I guess we don't. So that makes it easy for you.
Okay, thank you.
Thank you for being here. We'll open this for a public hearing for anyone who'd like to speak on this request. Commissioner, good to have you.
Steve Sandlin, County Commissioner out in District 9. This is just right outside my area now, but used to be in my district. For a number of years, they've, had these things that you can see out there, the little picnic tables and stuff for people to eat. I think what they're wanting to do is try to make it safer for folks that are wanting to eat there at the market, in which they have a lot of business. You don't see a lot of country stores anymore, and the gas pumps, are out right at the line anyway right there, and I know y'all got a tough decision to make, but I don't see any problem with it, and I haven't had any calls on it neither, so I wanted to give that piece of advice. But I believe what they're wanting to do is make it safer folks to eat than what's out there right now in the little picnic tables and the canopy and everything. So I appreciate you to.
Any questions of Commissioner while he's up here? Thank you. We appreciate it. Anyone else? Close the public hearing. Any discussion? I'll entertain a motion.
Mr. Chairman, I make a motion to approve.
Say that again.
I make a motion to approve.
Motion to approve. Do we have a second?
Second.
Call the roll, please.
Keith Bratcher,
Yes.
Joe Crowell,
Yes.
Jerry Sartain,
No.
Jared Barrett,
Yes.
Thane Cantrell.
Yes.
Motion carries, sir.
Next item we have is a request by James Sawyer, who is requesting a special exemption approval on accessory dwelling. What do you have on that, please?
Application Board of Zoning Appeals 2013-6 is a request for special exception approval for an accessory dwelling unit that does not meet the design standards for ADUs for a property located in a residential medium zoning district. And what the applicant is requesting is to construct an addition, an attached accessory dwelling unit on the property. It's located at 646 Cottonfield Lane, and it's a 0.53 acre parcel. And the acreage alone, to construct an accessory dwelling unit by right, it requires a minimum of 1 acre. If you do not meet that minimum of 1 acre, you automatically have to receive special exception approval from the Board of Zoning Appeals. In addition to the lot area, the proposed ADU will exceed 25% of the principal structure that's existing, and it's proposed at 1,012 square feet. And with that, based on the principal structure being 3,030 square feet, it is 33% of the principal structure size. So those are two requests for relief from the ADU standards. Apart from that, the proposed ADU is designed to match the existing dwelling. As you can see, this is an established neighborhood. They meet all of the criteria. In fact, they've already determined that there's an upsoil area. The proposed accessory dwelling unit meets the setbacks, and the applicant has supplied us with many elevations and plans to show that this has been well thought of. thought out, and we posted a sign on the property. We did receive one letter from a surrounding neighbor that was notified that they were not in favor of the request, indicating that the size of the structure, that it would require additional land area, that it would be more appropriate for a larger lot. Now, this is a photo of the backyard where the addition will be constructed and neighboring yards. And staff finds that the application meets the criteria for conditional special exception approval, and we recommend approval. And that concludes our presentation. You'll just see some of the site plans and elevations of the addition in relation to the principal structure. And the overall plan, the shaded area is the principal structure, and the white area is the ADU, in addition to a sunroom addition that will serve both the ADU and the principal dwelling. And that concludes our presentation.
Do we have anyone here representing this request? If you'll come around, please.
My name is Jim Soyster, and I am the resident of my wife and I are residents at 646 Cottonfield Lane. The primary, just wanted to make sure everybody knew the primary purpose of this addition is to give my parents a place to stay with us. They've actually moved in with us now already, but the purpose is to, give them some space of their own to, to live with us.
Any questions? Looks like you answered all of them. Thank you. You may be seated. We'll open this for a public hearing for anyone who'd like to speak on this request. Commissioner.
Gary Farley, County Commissioner, District 7. This is also, I live in this subdivision, and when Jim came to me with this proposal, I asked him to go talk to the neighbors. He's done that. I've received no calls on this. I didn't. You said there was a letter that was against it. I'd like to know maybe where the address is at, but just for informational purposes.
Yeah, she'll give that to you. Go ahead.
I'm in favor of it. I don't have a problem with it. Their home is a nice home, and then they'll fix it up and it'll look as good or better.
Any questions? Thank you, Commissioner. Anyone else want to speak for or against? Close the public hearing. Do we have a motion?
Mr. Chairman, I make a motion to approve.
Have a motion to be approved. Do we have a second?
Second.
Got a second. Call the roll, please.
Keith Bratcher,
Yes.
Joe Crow,
Yes.
Jerry Sartain,
Yes.
Jared Barrett,
Yes.
Dane Cantrell.
Yes.
Carry, sir.
The next item we have is a request by Avant Lane and Gerald Sullivan. This is concerning the Rogers Group plan, which was approved, approval and non-conforming use, which was approved by the Planning Commission. What do you have on that?
Okay, there we go. Little technical difficulties there. Okay. The application that you'll be considering right now is, all of this is in regards to a piece of property located along Burnt Knob Road. The address is 5920 Burnt Knob Road. It's the location of the Rogers Group quarry. This property has a very long and complex history regarding the use of the property and how it was originally approved and everything. I won't get into all of that, as at least at this point. Basically, a lot of the issue, or most of the issues that will be considered tonight, or pretty much all the issues that we consider tonight, deal with decisions that were made at the December 10th, 2012 Planning Commission meeting. And this is directly from the application that was submitted by the applicants. The site plan approval on December 10th, 2012 of Rogers Group site plan, the planning director's determination that Rogers Group activities on this property are non-conforming use as defined by state and county law, and David Jones's decision not to punish the Rogers Group and Jenny Justice for violating the zoning ordinance. Again, these issues all stem back to the Planning Commission meeting on December 10, 2012, when a site plan was presented to the Planning Commission and approved by the Planning Commission regarding certain accessory structures at the Rogers Group quarry. I know that there are representatives from the Rogers Group present, as well as representatives for the applicants who will want to speak. So with that, unless there's any questions, I'll turn it back over to you, Mr. Chairman.
Have anything else? Okay. All right. Do we have anyone here representing this request? If you'll please come around. Attorney Jackson, good to have you.
Good afternoon. My name is Jay Jackson, and I'm a lawyer. I'm a partner at Mitchell & Mitchell in Murfreesboro here in town, just around the corner. And I represent the Mr. Avant Lane and Mr. Gerald Sullivan as it relates to the appeal that we have filed of the Planning Commission's actions. What I would like to do is that Mr. DeMasi, the one thing we will agree on is that this site has a long and storied history and a lot going on with it, and still has a lot going on it. There's still 2 currently pending lawsuits related to this property involving both the county and Rogers Group and Mr. Avant Lane and Mr. Sullivan. But this is how we got where we are. Back in the early 80s, Stoneman, a group, basically came to the county and said, we want a rock quarry. We want to take the Blackman area, this area in Blackman, and we want a rock quarry. And they came to the Planning Commission to get approval for the rock quarry, and basically the Planning Commission turned them down. Stoneman, not believing that the Planning Commission had acted legally, filed a lawsuit in order to obtain the right to operate a rock quarry, which ultimately they did. In that lawsuit, I think, if I remember right, the opinion was issued in 1985. And it wasn't until after that time, it's my understanding, that Stoneman then began actually operating the rock quarry. What's at issue here is that at the point at which Stoneman came to the county and said, we want a rock quarry, I think the reason why the Planning Commission denied it was they didn't really want a rock quarry, and they realized, hey, we don't have any laws here regulating rock quarries, anything specific or anything going on. And so in 1984, they passed a comprehensive zoning law, brand new comprehensive zoning law, the law that basically was just replaced here this past year. And in that comprehensive zoning law, they did put significant restrictions, and they did put limitations, and they did put restrictions as it relates to setbacks, as it relates to some of these other issues and other things on rock quarries. And so what's happened, though, is that this plan that Stoneman came up with was real specific. It was a site plan that said we're not going to dig any deeper than 60, I think it was 65 feet. And we've got a specific pit area. What's happened over the years is that they are far deeper than they ever planned on being. The quarry is huge compared to what the original plan was. And nobody, maybe because of the court opinion, it was in litigation and whatever the case may be, but nobody from the county ever paid any attention to this quarry. So what did they start doing? Well, they started putting structures up, and they started putting this and that and everything else, and not once did they go to the county and get a permit. Not once. And so only after my clients filed a codes complaint and then had to file a lawsuit did the county finally do something about coming and saying, okay, we need to look into this. Now, there are some issues that the county and my clients have legitimate disagreements on. They're going to be resolved in court. But the county did seek to enforce the issue of the failure to obtain permits for certain structures. Mr. Jones testified about that in his deposition, and that was the end result of this site plan that ended up coming to the Planning Commission in December. The whole point and purpose of that, I guess, was to bring them in conformity with the law because they had not obtained permits for all these structures. So basically, we've got a quarry. It's been out there since 1984, hadn't even been looked at, hadn't been monitored, hadn't been watched, nothing's happened on it. And then finally, my clients speak up and do something about it, and finally the county starts to take action. Well, Rogers Group put together this comprehensive site plan, brought it to the Planning Commission to get approval. And one of the issues that I brought up had to do with, well, what law applies? Does the 1984 law apply? Another issue I brought up is you've submitted a site plan that has commercial structures or structures that are designed for a commercial and industrial purpose. The land is still zoned residential. The Rogers Group, or the owner of the land, never made a request along with this site plan submission to change the zoning. They just want you to approve commercial and industrial zoning type structures in a residential zone. And therefore, I think at the Planning Commission, what ended up coming up was that, well, if they're allowed to be there in the first place under the old law, we can't do anything with them under this 1984 ordinance, then you know, I don't know what the Planning Commission thought because it wasn't real clear. I'm just assuming a little bit that maybe that they thought, well, we don't really have a whole lot of choice. And, you know, they're allowed to be here by this court opinion, so there's not a whole lot we can do about it. So we're just going to approve this site plan, even though we're approving industrial, commercial type activities in a residential zone. I mean, what the Planning Commission did is they created a precedent that would just be wonderful for most people that have commercial and industrial desires in the county. I don't have to go get the property rezoned now. I don't have to. All I have to do is I can avert the public notice process, and I mean not the public notice process, but I can avert the public hearing process. I just submit a site plan that has all the stuff in it that I won't need to operate my business. And I just get the Planning Commission to approve that. And it don't matter if I have residential property or not. So one of the issues we think is significant, is that the Planning Commission approved a site plan containing obviously structures designed for a commercial and industrial purpose in a residential zone, which is not in compliance with county law. And there's no county law that would authorize such approval under those circumstances. And if you read the ordinance or read the zoning law that was in effect in December, if you read it and you look at it, it's totally inconsistent with what is designed for residential zoning. So what the Planning Commission did is they approved a site plan that contains structures in it that are totally inconsistent with a residential zone. Okay? The next issue has to do with whether or not it is or is not a non-conforming use. Mr. DeMasi was asked more than once by the Planning Commission whether or not he thought this was a non-conforming use, and he said he thought it was a non-conforming use. Well, Mr. DeMasi is not correct. It is not a non-conforming use. And I have provided y'all with information, and the most recent Tennessee Supreme Court case that specifically deals with how you establish a non-conforming use. And one important part that I brought this up at the hearing in front of the Planning Commission has to do with the actual operation requirement. And that's something that Rogers Group is not going to be able to demonstrate they can comply with. Mr. DeMasi never explained to the Planning Commission how they met the actual operation requirement. But I do know this. With the Planning Commission's asking him twice for that, that's information they thought was really relevant and important. So I want to talk a little bit about that. But basically, Tennessee law has a statute, TCA 137208, which, I'm sorry, Tennessee Code has an annotated statute, 137208, which talks about what is and what is not a non-conforming use. Over the years, of course, like all statutes, they get interpreted by courts. And courts, Tennessee Court of Appeals, Tennessee Supreme Court, basically takes a statute, they interpret it, and they say this is what it means. This is how you apply it. And the most recent case which dealt specifically with that is this Ready Mix case. It was decided in August of 2012. It was the Tennessee Supreme Court. This is not me. This is not Mr. Lane. This is not Mr. Sullivan. This is the Tennessee Supreme Court. Don't take my word for it. Don't take Mr. Murphy's word for it. Don't take Rogers Group word for it. Take the Tennessee Supreme Court's word for it. You can read their words. It's in there. And it specifically has an actual operation requirement. And what that means is that you cannot be a non-conforming use unless you were actually in operation at the time of the zoning change. And if you read Ms. Garrison's letter to this commission, or to this board, if you read her letter closely, you'll see in there where she acknowledged that there were no operations going on by Stoneman at that particular time. She focused on the investment and the land and all that. But the Tennessee Supreme Court made it clear the actual operation requirement exists and it has to be met. And Mr. Murphy spent a lot of time up here last time talking to the Planning Commission, talking about the diminished assets doctrine. Well, it's interesting, Ms. Garrison in her letter on behalf of the Rogers Group never mentioned it. And the reason is because I don't know if Mr. Murphy, exactly why he didn't see this, but the diminished assets doctrine has not been adopted by the state of Tennessee. It's not been adopted by the Tennessee Supreme Court. They did talk about it, but they specifically did not adopt it. So it's not law in the Tennessee, and it can't be considered by the state of Tennessee. It can't be considered, was not considered by the Tennessee Supreme Court. And in fact, in this last letter that I sent to you guys, sent to y'all today, Tennessee Supreme Court cited some cases and some case law talking about actual operations, talking about them. And I quoted something. And this is the Tennessee Supreme Court. This is not Mr. Jackson. This is not Mr. Sullivan. This is not Mr. Lane. This is not Mr. Murphy. This is the Tennessee Supreme Court. And what they say is, nevertheless, mere preparation of the property for operations is not enough to establish a pre-existing non-conforming use. And then they go on to talk about, these cases, and they talk about cases where there was actually a blast set off. There was actually a sale of rock at a particular quarry. And they said, no, it's not enough. And what we know from the letter submitted by the Rogers Group is that they didn't even have that. Don't take my word for it. It's in her letter. And so the last issue that we have an issue with is we don't understand why county citizens are repeatedly, are many times punished for violating codes. Yet we haven't seen any indication from Mr. Jones that the Rogers Group has been fined 1 penny or $1, has been cited, has been brought into court to answer it all for their failure to obtain permits for all these structures on this property. And we don't understand why that's the case. We can't figure that out. We're hoping this board, in looking at some of this, fresh eyes, looking at some of these things that have happened, can help my clients understand why there does not seem to be any accountability to the Rogers Group for the stuff that's going on out there. And so what we're here for is that we'd like this board, where we've appealed these decisions. Mr. DeMasi made his decision that this was a non-conforming use. We've appealed this approval of the site plan. And, you know, there are some emails exchanged by Mr. DeMasi and an attorney in Nashville discussing some various things. It may be that the whole thing needs to be thrown back to the Planning Commission. You know, maybe they need to relook at all this. Is this a non-conforming use or not? Is this a site plan or not? I'm not sure how much prejudice there's going to be to the Rogers Group, especially considering the fact that it's been 2 years, they haven't been punished anything yet. I doubt they're going to be punished anything in the future. So what we're asking you to do today is to reverse what happened back in December. because it was wrong. And it was not in accordance with county law, and it was not in accordance with state law. And we want you to find out from Mr. DeMasi why he thinks this is a non-conforming use. He said it was twice, but he never explained how they met this actual operations requirement. This is not something, this law is not something that can be ignored. It's something that this board has got to get a legitimate answer to. What actual operations did they have going on? With that, I'll pass the floor.
Wait just a minute. There may be some questions. Have any questions? Thank you. Appreciate it. We'll open this for a public hearing at this time.
I don't have any questions of Mr. Jackson this time, but after we kind of hear some other stuff, if we have some, then can we bring them back?
Yes,
okay.
We'll have an open discussion after we hear from all the parties concerned.
Thank you.
Come around, please.
Good afternoon, Chairman Cantrell, members of the Board of Zoning Appeals, and staff. I'm Brick Murphy of the law firm of Murphy & Murphy, and I represent the property owners, the Rogers Group. Here today on behalf of the Rogers Group are many of their employees. Y'all might want to look back. These are the people whose livelihood depends on this quarry. This quarry provides valuable services to this community, and it's been legally operating. I don't know why Mr. Jackson thinks that you or anyone else should punish a business for operating legally and providing a service that's legal under the law. That just baffles me, but I'll get into the legal arguments in a second, but that just seems kind of against what America is about, to try to punish people for operating businesses and employing people.
Well, I would appreciate it if you would stick with the subject.
But that being said, I was responding to Mr. Jackson's comments. In support of Mr. DeMasi's position, I'd like to begin with saying that Mr. Jackson's analysis of the nonconforming use law, while somewhat relevant, we satisfy the factors necessary to be a nonconforming use. And I want to remind the board to that end that what's most relevant and applicable to this case is the Stoneman decision, which is exactly on this particular quarry and this particular site. This isn't some theoretical argument. The Court of Appeals looked at this site and this operations and determined that it was legal. In the Stoneman case, which all of you have in your packages, addresses the specific quarry and specifically says that the quarry was approved to operate pursuant to the zoning code in place in 1982, which made this quarry a use by right. Therefore, no rezoning was required. Therefore, we need not need to delve further into legal analysis, although I feel like that I must. Because the Court of Appeals already looked into the facts of this quarry, and their opinion, in essence, rendered this quarry a nonconforming use. As such, the county has interpreted the quarry as a nonconforming use. Planning and land use lawyers across the state agree with this opinion, and Mr. DeMasi likewise agreed that this quarry was legally operating and was a legally operating nonconforming use. Now, before I delve into addressing any more of the details of a nonconforming use analysis and Mr. Jackson's arguments regarding this analysis, I'd like you to carefully review the facts laid out in the Stoneman decision so we can all understand the Court of Appeals holding as it applies to this particular quarry. Not theoretical, this quarry. While the facts of every case are important, in this case it's absolutely critical to Mr. DeMasi's decision that this is a nonconforming use, and so I'm going to have to go through and focus a little bit on these facts. I've outlined the facts surrounding the quarry in a timeline prepared for you, and Mr. Ted Goodman from my office will circulate that. Without boring y'all to tears, as you can see, it's a quite extensive timeline of facts. I've also addressed the most relevant facts in a letter in support of our position in a package. The letter was circulated. It's dated February 11th, and our legal arguments in the timeline are detailed and are relevant to this quarry. Does everybody have a copy of that February 11th letter? And we'll circulate the timeline. Great. I'm going to go through a couple of the relevant facts, and I'll try to keep it brief. 12 years ago, the Rogers Group purchased this quarry from Stoneman. This quarry was not a permitted conditional use. Stoneman did not permit the quarry as a conditional use, and Rogers does not have a conditional use. Both Stoneman and Rogers relied on the Court of Appeals' affirmative ruling in 1985 that the quarry must be sited on this property and that it should be treated as a permitted use by right under the 1982 laws that were in place in this county. In the appeals case, the appeals case was basically to determine if a quarry was permitted on this site, and that's a Stoneman versus Rutherford County case, which I've attached to the February 11th letter. As you review this case, you'll learn that the facts involve a long and tortured approval process that makes this case particularly unique. In March 1982, Stoneman filed a petition with the Rutherford County Regional Planning Commission seeking approval of a new quarry to be located in an agricultural district. It wasn't zoned residential, it was agricultural at the time, along Burton Arm Road, and at the time, quarrying was permitted as a right in 1982. Stoneman filed this site plan because while quarrying was permitted as a right, the zoning ordinance and subdivisions regulations required that the quarry obtain administrative approval of a site plan before they engaged in quarrying. In March 1982, once again, the site plan was submitted for preliminary approval. At a Planning Commission meeting on June 7, 1982, the planning director at the time advised the Planning Commission that the proposed quarry site was properly zoned for quarry and stated that the application for the quarry met all the requirements set forth in the zoning regulations. In fact, the planning director stated that application met all the requirements on at least 3 different meetings on this exact application. Nevertheless, Rutherford County denied Stoneman's site plan approval. Subsequently, Stoneman was forced to file suit against the county challenging this decision. Rather than admitting fault, the county moved forward with processing Stoneman's application during the litigation. However, again in 1983, Stoneman faced additional hurdles placed on it by the county. At that time, on 2 separate occasions, the Planning Commission was asked to approve a final site plan approval, which they denied despite the fact that the Commission was advised that the Stoneman application met all local requirements and that, and I'm quoting, a rock quarry meeting these requirements was entitled to locate in an area zoned for agriculture as a matter of right, end quotes. As a result of the Planning Commission's unlawful decision to deny the site plan, Stoneman was forced to proceed with a lawsuit against Rutherford County for its denial of its site plan. And Stoneman's argument was that the denial of the site plan was illegal and arbitrary because the site plan complied with all the requirements of the zoning ordinance and should have been immediately approved. That's the law. Both the trial court on this particular case and the Court of Appeals reviewing the trial court's case reviewed it according to the 1982 zoning ordinance, which permitted quarrying as a use by right. And both courts agreed that the permit should have been issued in 1982. In fact, the Court of Appeals specifically stated that Rutherford County was prohibited from imposing additional conditions not contained in the then existing ordinance adopted by the county legislative body, and the court, in its opinion, specifically referenced the 1982 ordinance, which permitted quarrying by right. They could have referenced 1984, but they didn't. The 1982 rules, or what they said, applies. Accordingly, in response to the Court of Appeals order, the Rutherford County Planning Commission, in its May 6, 1985 meeting, voted to grant a permit for the Stoneman Quarry pursuant to the court's order, and the grant of permit contained no conditions on the operation of this quarry. After Stoneman was granted a permit, the site plan originally submitted in 1982 was finally approved and filed despite the fact that the new ordinance was adopted in 1984, which made quarrying a conditional use rather than a use by right. Now I've outlined the facts. I'd like to reiterate that the Stoneman case is what's controlling, not some other legal theories, the Stoneman case in particular. While there's an extensive body of case law on nonconforming uses in Tennessee, no specific case addresses these particular facts and this particular quarry besides the Stoneman case that went all the way to the Court of Appeals. Therefore, it's extremely important to note that the nonconforming use analysis as it currently exists in Tennessee, while instructive, does not control this particular site. Instead, what is controlling is the Stoneman decision. Stoneman case, once again, applies directly to this property. There's nothing else that is relevant to this inquiry other than the Court of Appeals case. As I just explained in discussing these facts, it's important to note that the Stoneman case indicated in very clear terms that the quarry should be permitted and approved under the 1982 zoning ordinances. And it was a use by right at that time, no conditional use permit required. In determining the Stoneman case, the Stoneman case and the determination in it is what has controlled and guided Stoneman and the Rogers Group use of this property since 1985, and has also controlled and guided the county's understanding and treatment of this quarry to this day. Meaning for the past 20 years, it's operated as a legally operating business, considered to be a non-conforming use and treated as such. Why? Because the Court of Appeals told us that was the case. Stoneman, in that case, they made it very clear that the zoning change, even though there was a zoning change, the site plan should be approved and processed and approved under the 1982 laws. Therefore, it's very clear that they treated it as a non-conforming use. The Planning Commission agreed with this position. Mr. DeMasi, your planning director, agreed with this position, and we ask you to agree with this position. This is a well-settled issue of law that applies to this particular quarry, this particular issue, and it's been decided by the Court of Appeals. Notwithstanding that issue, though, and notwithstanding that argument, we feel like we meet the nonconforming use statutes, and here's why. To invoke the protection of these statutes, the parties seeking protection must establish two things. One, there was a zoning change, and two, at the time that zoning change took place, they had a right to operate the use that was being operated on the property. In this particular case, the Rogers Group satisfies this requirement, and the board's decision should be upheld. Focusing on prong one, the Rogers Group satisfies this prong, which is basically, was there a zoning change? There was. The Court of Appeals remanded this case to the trial court, and the trial court was directed to remand it to the Planning Commission for timely action on the Stoneman site plan using only those requirements contained in the county zoning ordinance found enforceable in the Stoneman opinion, and that's a quote. Accordingly, this ruling affirmatively said it should be treated as a nonconforming use, and in response to this order, the Planning Commission approved it. The quarry was approved pursuant to the 1982 ordinance. We also feel that the Rogers Group satisfies prong two, and that they can demonstrate use of the property because there was a demonstrated devotion to the property as a quarrying site dating back to the time that the site plan was applied for. First, quarrying was permitted on the site in 1982, and the Court of Appeals opinion in Stoneman clearly said it was permitted in an agricultural zone. So we satisfy that requirement. Second, regardless of whether or not the quarry was operating at the time, Stoneman satisfies the second prong of the requirement because of the Court of Appeals opined in its order that the quarry should be permitted under the 1982 zoning ordinance and treated as a nonconforming use. The court did this for the same public policy reasons outlined in the Tennessee Supreme Court case 20 years later in Harding Academy versus Metro Government of Nashville and Davidson County, which is a 2007 case. In the Harding Academy case, the school wanted to tear down 9 houses to use the land as athletic fields. During the process of trying to get approval to do this, there was a proposed zoning change to make the land in question a historic district, which would have prohibited the tearing down of the houses and the use of the land as ball fields. Harding Academy applied for demolition permits, which were initially granted, but several days later were rescinded by Metro Davidson County under the theory that there was pending legislation. Ultimately, the Supreme Court of Tennessee said the demolition permits never should have been rescinded. However, the problem in the Harding Academy case was the Supreme Court had to deal with how to implement this decision, since this case was held up in litigation for years, and during that time, the standards for demolition permits and the zoning for the Harding Academy property changed. Just like in our case, the zoning changed during the litigation, and Harding Academy was prevented from tearing down the houses due to the pending litigation. In the Harding Academy case, the court held that when a city held that it would be unjust to order Metro to reissue building permits in the Harding Academy and then say that Harding Academy cannot be relied on those permits to demolish the structures, end quote. In the Harding Academy case, the court held that the city or the county in this case, if they deny the property owner's request for a lawful use, and that denial is arbitrary or wrongful or in bad faith, that government body can't argue that a zoning change makes a use unlawful, because the wrongful denial of the permit is what prevented the property owner from its desired use and thus prevented the property owner from having a vested property right before the zone change. The county can't say that we're non-conforming because it was the county's unlawful denial of our plan that prevented the quarrying of the property. In essence, the court in the Harding Academy case found it was fundamentally unjust to deny an otherwise unlawful use and have the government then say, well, guys, you don't get grandfather clause protection. The same theory applies to our case. They would have operated the quarry and opened it in 1982 had the county followed its own rules and regulations. It was the county's lawful act that prevented us from getting out there and quarrying, and therefore the county cannot come back and say, you're not a non-conforming use. And in our case, it was the denial of the site plan and the torturous process the county made the Stoneman property go through that resulted in the quarry not being open till 85, when finally the Court of Appeals said, guys, y'all have to let them open. Y'all have to grant this site plan. In addition to this argument, we feel that we are vested. The Ready Mix case that was cited earlier says that actual quarrying doesn't have to take place. And for a period of 3+ years, in this case, Stoneman had substantial reliance on the zoning ordinance in 85 that said they had a use by right. They were denied the site plan, and that's what prevented them from quarrying. But they did do other things that would have vested them. They invested time, money, and substantial resources in the site plan in direct reliance on the fact that the zoning was in place in 82 to allow this quarrying. While the activities didn't necessarily include blasting and quarrying, they were substantial enough to demonstrate a devotion to the property as a quarry, and pursuant to the Supreme Court case in Ready Mix, that's sufficient. In the ready-mix case, which was just decided, the court takes a very liberal approach to what is required to demonstrate a devotion to quarrying. In the ready-mix case, the court recognized that quarrying operations were substantially different from other businesses, and that they're fundamentally different from those businesses, and that the standard analysis that's been applied in most non-conforming use cases isn't really applicable to this kind of business, because how a quarry is operated is different than how a strip center or Nissan or something else is operated. Quarrying companies hold reserves on tracks for future use, and these reserves are a critical part of their business. And active mining is not required, says the Supreme Court in ready-mix. One of the things the court points to in ready-mix is a devotion to quarrying, and that the ready-mix property owners had applied for stormwater and air quality permits from the state to allow quarrying, and that these applications had been made before the zoning change. They actually made applications. They had substantial reliance. In our case, not only did we make applications, but Stoneman submitted a detailed site plan in reliance on the zoning code as a quarrying, as a use by right. And Stoneman did this because they'd identified proven reserves on this site. Moreover, Stoneman not only applied for, but actually was granted stormwater, air quality, and other permits permitting quarrying a good 2 years before the new zoning ordinance was adopted in 1984. This is just one example of Stoneman's devotion to quarrying on this property. And as such, the Rogers Group, as a successor in interest to Stoneman, meets the obligations of showing that it was an operating business because they had substantial devotion to the use of the property as a quarry. In conclusion, the quarry has a right to operate. This issue was resolved many years ago. The quarry has been in continuing operations for 28 years, and my clients, as the successor to Stoneman's operations, have a clear right to operate this quarry as a non-conforming use, which it has been for all these years. I have the utmost respect for Mr. Jackson and his clients, but this is not an unsolved mystery. This issue has been litigated, and it's been decided by the Court of Appeals of our state on this particular fact scenario. The Chancery Court and the Court of Appeals both agreed, and the holding of this case unequivocally gives the right to operate this quarry. For these reasons, we'd ask you to approve and Mr. Doug DeMassi's opinion that this is a non-conforming use and that should be upheld. The Court of Appeals recognized this and appreciated that this was a non-conforming use and that Stoneman had a vested property right to operate this quarry, which was improperly denied by the county and unnecessarily dragged out. And the quarry therefore qualifies and was approved per the 1982 ordinance. Therefore, we ask you to uphold Mr. DeMassi's decision and to affirm what the Court of Appeals has already told us. This quarry has a right to operate. Also, briefly, Mr. Jackson and his clients have appealed the decision of the Planning Commission to approve the site plan. I think this issue is clearly resolved in our law that the BZA has limited authority, and the BZA's authority under the law is limited to the review of 3 things, no more, no less. And those things are basically a refusal of a county building commissioner or administrative officer to carry out the enforcement of an ordinance. That's not a site plan, and that's not the authority to review what the Planning Commission did. Requests for special exceptions, like variances, which were before y'all earlier, and particular hardships that are generated by the shape or physical features of a piece of property that make it an exceptional hardship to comply with zoning ordinances. Likewise, the county zoning code states that this board shall have the authority to hear appeals for an order or requirement or decision or any department, office, or bureau responsible for the administration of this resolution. In a very similar case, in a Brentwood Academy case, the landowners challenged the approval of a site plan by filing an appeal before the BZA, and the court specifically found in that case, which was a Court of Appeals case, that the Planning Commission is not another administrative office, and its decisions to approve a site plan was not made as a part of carrying out or enforcing the zoning code. Instead, its decisions were based and properly decided on independent authority, which is granted by our Tennessee legislature under Tennessee Code annotated 13-4-104, and accordingly, the Planning Commission's approval of the site plan in the Brentwood Academy case was not reviewable by the BZA. And for the aforementioned reasons, we request that Mr. Jackson's request to appeal the decision of the site plan approval from the Planning Commission be denied based on the state and county's rules and ordinances that apply to what can be reviewed by the BZA and what can't be. So we appreciate your time, and we would like you to deny both of Mr. Jackson's requests.
We have any questions?
I got some questions. You talk like they employed several people out there. How many people do they employ?
I'm sorry?
How many people do they employ on site? You let on like there were several employed there.
Well, all these people are employees of the Rogers Group.
I'm talking about at that location, how many people are employed?
23, I'm being told by
23. What years was this crusher shut down with no rock being removed?
Well, I really don't know the answer to that question. I believe it's been in continuing operation, and as long as it's in continuing operation.
Okay, I'm gonna use an example. I bought some land in 1991, and I had a mobile home lot, and I let 1 year pass by, and I no longer could set a mobile home back on that lot.
Okay.
Now, I'm kind of looking at this as being the same situation. If you were not in operation during a period of years, you may be looked on and viewed as the same way as my mobile home lot was. I don't know the answer to that.
Is your question whether or not the
I would like to know what years that it was actually no gravel being removed from that site.
My understanding, it's been under continuing operation, and the grandfather clause, which is a non-conforming use clause, says that as long as operations continue and if operations are stopped, then and are started again in 30 months, then you still get grandfather clause protection.
My mobile home lot, 1 year, and 1 day I lost the use of it in this county because 1 year passed.
Well, I'm sorry to hear that. It sounds like
no problem. I don't have any problem with it, but I'm looking kindly at this like my mobile home lot. Thank you.
Any other questions? Thank you. You may be seated. Do we have you folks may, I'm sure you're getting tired. You may be seated too. We have anyone else? This is a public hearing, so we want to gather as much information as we possibly can. Please keep your comments brief and to the subject.
Thank you, Mr. Moderator. My name is Avon Lane. I live at 221 North Highland, downtown. And as you can see, this is a long and convoluted, complicated situation. But what I want to bring forth, and I won't take just a small amount of time, is that being up there in the folks in Blackman around Burnt Knob, when Stoneman came in, it was fault, and the state decided to force the county to give them a permit to operate. Now, what I understand, I don't know if you gentlemen have a copy of that permit. That permit is the site plan. This is what I've been told from the Planning Commission, from the state, from everybody, that permit is that site plan. And on that site plans, it has things like hours of operations, the depth, and those type things. Now, as Stoneman went in operation, everybody was really upset. Time went on. But they were a pretty good neighbor. Nobody hurt them too much. So everybody kind of, well, it's up there. We can't do anything about it. Excuse me. It's legal and everything. We'll live with it. Well, as time went on, things changed that we didn't know changed. The Rogers Group, all of a sudden there's a Rogers Group sign up there. Okay, but in this interim period, there's the 1984 zoning resolution that was enacted and came into being, which was caused by this particular case, to address those issues about how things are to be set up. Well, as time went on, well, Rogers, they never came, they never said a word to the county. Nobody knew. They thought it was just an extension of Stoneman. It wasn't Stoneman. If you'll look in the old trial that the judge talked about in the state, in some of the documentation there was a statement said that Stoneman thought there was only maybe 6 or 7 years of rock up there, and that's about all they'd be up there. Well, you know, folks, that's about all they were up there. They got down to the depth of 60 foot and called it a day and left. Those questions haven't been asked me. Why did they leave? Was it, did they assume now we've gone the limits of this permit? That's the site plan with all the stamps and stuff by the state and the county and everything. They've gone to the limitation of that, and they have to call it a day, move on. Well, I don't know what transpired, but there was a company before Rogers that came in there for a little while or whatever. It's very convoluted, but they started operating. Never said hello, goodbye to the county. This went on. And then as time went on, the rock started getting harder, the noise got bigger. The thing said, what is going on up there? So I started checking. Found out that the rock core was that 400 foot deep. And I said, well, is our county doing anything? I thought all this time our county had been monitoring this thing. So I called the state. I asked them, well, who's responsible to make sure that they're compliant with the site plan? Is it the state? And they had to have state permits. But that's not the permit that the state said, that's not what we're worried about here. You're asking about who watches the day-to-day operation or monthly operation. They said that comes under the county, municipalities, or the city. So I called Mr. Jones. And this has been a pretty good while back. And Mr. Jones was forthright. I said, he had this deer in the headlight look at me. When I asked him, he says, I really don't know, but I'll find out. And he essentially told me, we can't go up there. Now, I don't know why he came to that decision. He says, there was a state law, suit and all that, and he told me that. I don't know why he made that decision. But be that as it may, to finish this thing up, we're talking about Rogers Group and we're talking about Stoneman this. It's two different things here, folks. That rock quarry that's there now is not the rock quarry of 1982. It's not even close. It even had hours of operations on it, and things like that were pretty good. Everybody, if they would go to that, if they would stay with their original site plan, I wouldn't have a problem with them. But they're 10 times bigger. They got hundreds and thousands, millions of dollars of equipment that have been moved in. There has been no permits, building permits, one iota. I can't get Mr. Jones. Why haven't we gone up there and checked this stuff? The thing is, the site plan, as-built site plan that I've looked at, there's tremendous hairs with it. There's supposed to be a mile circle from Inley School, and that was discussed over the years, and the 1,500-foot setback. Well, this new as-built violates another thing. There's a big settlement pond over there against my property. It's not supposed to be there. They never were supposed to build it. But they've just arbitrarily, and I don't know what they were thinking, it's almost to the point of being arrogant. We'll just go ahead and do what we want to do, and devil take the hindmost, and the county, they're not going to do anything. We weren't defended very well at that last, the county wasn't defended very well by its legal staff at that particular time. And with that,
Were you able to make your statements before the Planning Commission in December? You took this same information?
Well, no, sir, I didn't. They've had this information. They have all this information.
But they had a public hearing on this. Is that correct?
It was very short and sweet and to the point. This is why we're at
the only reason I'm asking.
Well, we're in a lawsuit also. In this lawsuit, gentlemen, all these questions are going to be asked, and a whole lot more questions that will be resolved, hopefully, at the lawsuit, and we'll come to the end of this thing. Right. Don't get me wrong. I have no problem with business. I have no problem with the rock quarry. I just want them to play by the same rules as that poor gentleman that had put his cars out there on the floodplain, and Mr. Jones and them sent a guy and arrested a 93-year-old man. He has to obey by the rules. Then they're a multi-billion-dollar company, I grant you. But
well, thank you. We appreciate
I'm
your
sorry.
information.
I got a question.
Yes, sir.
Your property, Jones, this property?
Yes, sir.
What years was this not in operation?
Beg pardon?
What years were they not removing rock?
I can't tell you.
How many years were they not removing rock?
I don't have that information.
You don't have any idea?
No, sir.
Thank you.
Thank you. Anyone else? If you'll come forward, please. Please keep your comments specific.
I'm Gerald Sullivan. I live at 6018 Burnt Knob Road. My property backs up to the quarry property. I can straddle the line. That's how close I am. And I can sit in my living room and look out the back window and see the operation going on, especially during the winter months. But I want to just say one thing. Their lawyers talking about them following their site plan. No, they're not following the site plan. I've got the site plans right here in my hand. It definitely says no more deeper than 60 feet was what it's supposed to be. 3 years ago, I was over there, and they'd already gone 380 feet. And so they're not working on that end next to me. They're working on the south end toward Mr. Lane's area. And they've done a lot of things over there, added. When I moved out there in 1990, well, Henson had been there before Stone Man, and the signs are laying over there on the ground on the property line. I can go through there sometime cleaning up brush and stuff and see the signs. And they had one holding pond and one conveyor. Now and I've been up in there in an airplane flying over it, getting pictures. And some of you people here probably have seen those pictures. They are at least 4 holding ponds over there now and 3 conveyors. And one of them you can see all the way from I-24. But that's it.
Thank you.
That's all I want to add to it now.
Thank you. Appreciate that. Anyone else want to speak on this? Please keep your comments specific to the request.
I'm Brian Dillard. I've been an employee at Rogers Group for 8 years. Thank y'all for having us out here today and appreciate your time. Just want to say a couple of things. We have been in continuous operation since 1985. There hasn't been a week gone by that we have not sold rock. So since 1985, it has been a continuous operation. We have, in fact, received permits from the state. We got air permits, water permits, and electrical permits anytime that we've done an expansion. In 2006, when we built the plant, the subcontractor pulled the pulled the electrical permits. So we have done that. And just want to say that we support Mr. Murphy's decisions, what he said, and hope that you do the same. Thanks.
Thank you. Question here for you.
Sir.
Just got one question. You didn't give your address. Do you live here in Rutherford County?
I do. I live in Gunpucket Road.
Thank you.
Anyone else? Commissioner, good to see you again.
Yeah, he's hot tonight. Steve Sandlin, County Commissioner out in District 9. The rock quarry is in my district, and I've been a commissioner out there since August of '90. So this precedes me. But as you can tell, a lot of things going on out there, and has been going on for a number of years. Let me first say, I am not an attorney, okay? So I put in my disclosure right there. I am on the Planning Commission, and I did not vote for the approval of the site plan for a number of reasons. All these years, we haven't had a site plan, and then now we have one. Really and truly, I thought the judge would have made a decision by now on the one or the two lawsuits that are involved with now or pending now, and that they would, or the judge would say, first thing you got to do is have a site plan, and let's present that to the Planning Commission and then to full commission. Stuff like that. Like I say, I first say I'm not an attorney because I don't know all the legal ins and outs, and hopefully Tom can shed some light on this in a little bit after public hearing's closed about what you can do and what you can't do as far as BZA. I don't blame the folks that own the property and getting an attorney to come up here and ask BZA to look at this. I didn't feel comfortable with it plan. That's why I didn't vote for it, and some others did too. Like I said, the Rogers Group hadn't been involved since '82 when all this was going. It was another rock quarry then. I don't think they come in until 2000, 2001, something like that. So I think they may have inherited something or bought something that, you know, is thinking that they've got what they need to do the quarrying operation that they want to do. I don't know. All I can do as a county commissioner, all I can do is assist. And I live right down the hill there in the Foothill subdivision. So, you know, we feel the shakes and stuff from the blast and all that. But, you know, we've reaped the benefits as county citizens and taxpayers from the quarrying of the rock, you know, from the taxes that have come off of it. And I don't deny them being able to do business. But they've got to do business in a way that's right and up front with the state and right and up front with the county. And so if that hasn't been done, then they need to get in compliance. They need to do what it takes to be in compliance. This site plan issue, I think, is premature. I think it should. I say that two ways, because I think a site plan should have been done when they first started working over there as the Rogers Group. But that didn't happen. We've got it now, and it wasn't court ordered. So why now? I hope that this doesn't. Well, I put it this way. I don't know what the site plan. It may help them out in the court proceedings or something. I don't know, by having an approved site plan. If it is, I think we've done something out of turn here as far as the County Planning Commission is concerned. All I'm wanting is, and I think everybody around there, or the majority of people, there's some people, no doubt, wants to shut the thing down. There's a lot of folks in Rutherford County that don't want or any county for that matter, wants a rock quarry or a landfill or something like that in their backyard. But one thing we have to remember is I get calls on a weekly basis, is that they were there when we moved in. They were there when I moved in. And all I can say and all I can ask for anybody in the public realm or in the governmental realm here is that they comply with the codes that they're faced with, just like me and you are every day, or any other rock quarry that is going on in Rutherford County or any other county in the state of Tennessee. That's all I'm asking. Y'all got a tough decision here to make, as usual, as you do every week, I gather, every month. But you need to look at this. If there's any problems, like I said, I don't know the legality, send it back to Planning Commission. Then we don't know what we're going to do there neither, I imagine. But, you know, this is something I thought, as I started the conversation off, that would have been directed down from the judge with these lawsuits. And I think the Rogers Group, in their behalf, is trying to do the right thing. I think they're trying to get in compliance or get the things that we need from the county. But it's not happening quick enough. And like I say, I've been out there and I feel a little embarrassed because I've been a county commissioner out there 23 years. And at the end of this term, it'll be 24, and this is still an issue. And I hate that because I feel like we've been tied as far as the Building and Codes Department. Maybe David's hands have been tied to back when it was the 82 issuance over there, what's come down through the court situation. But we need some answers, and we're not getting them. The public needs some answers, and they're not getting them. And these folks here that, you know, they've come out of money out of their pockets because they live there or they have property there to try to get the right thing done, and we haven't done that as a governmental entity. So we're just wanting the public safety and welfare of everybody around there that has moved in, and all these new subdivisions that have come in around them, and really come in around this area where they're facing the shock waves from all the dynamiting that they're doing from the quarry. And if they can continue doing that and widen their footprint and all that, go through the procedures that you have to go through, and every other quarry has to get that done. If they've gone beyond that and they need to close the doors, then they'll have to do that too. But I guess that's why it's in court. Thank you for your hard decisions. I'm sorry to bother you.
Mr. Sadlin,
yes,
are you requesting us to reverse this tonight? Is that what you're asking us to do?
I don't know what the attorney's opinion is going to be on this, but I wasn't happy with it in planning. I got overseen there, and I don't know.
What would
David,
you like?
Do you remember what the vote was at planning, or Doug? 7-3 or something. You know, I don't know what we'll do with it when we get back to planning, but if you're not comfortable with it, send it back, and we'll try to do something with it.
Thank you.
Yes, sir.
Thank you, Commissioner. Anyone else? We want to make sure we've heard everyone. That's what the public hearing's for. Commissioner, good to see you.
I hadn't intended to get up here and say anything, but there are a couple of things that have. Ronald Williams, I live out at Rockville. I used to be the commissioner that was out there, and I have done a lot more research into this than I really wanted to do on anything. So I'll just bring you up to what I know that hasn't been brought up here. First of all, about the 60 feet. That concerned me when I looked at that. So I go to Mike Williams, who was then the highway superintendent, and ask him about the depth of the quarry and was there any significance to the 60 feet. He said that it was, because in Middle Tennessee, basically the first 60 or 70 feet is the stone that's real brittle and porous. When you get below that, he called it some layer, and I apologize for not knowing all that, didn't intend to say anything. But when you breach through these next layers, there are four, the Murfreesboro layer and some of the other things, and I had requested that be looked at and brought that information before the bodies, before any decision was ever made. That's never been done. I gave some people information that could have been the college geologists, that they showed where the water flow was going and how it changed when you breach those lower layers that are harder and water won't penetrate it. You change the flow of the underground water streams. In their zoning regulations, there are 21 things that you must have. One of those in the zoning regulations that are supposed to be brought forward by the applicant are what 2 downstream rivers are supposed to do. That's never been brought forward that I've seen in any of the things, and that is one of the reasons that's one of the things that must be done before an application can be reviewed. That's never been done. So we have the depth that gets into different types of gravel that should have been studied before anybody makes a decision. The water that should have been studied that was required to have been brought by the applicant that was not done. And the last that you were talking about the continuation. Stoneman quit its operation, and I believe it was LoJack that came in there, and they tried to get a hot mix plant put in there for a period of time. And I don't know the timeline on this, but there was Stoneman, there was LoJack, or somebody that had gotten a hold of the property, and then after that was when the Rogers Group came in. So there was a group in between that. I don't know if it was a year, 2 years, or whatever operation. Could have been selling rock, I don't know, but there was another group in there that's not been mentioned. So I just want to bring those three things to you. Thank you.
Thank you. Appreciate it. Anyone else?
Hey, Mr. Chairman, I'd like to request about a 5-minute recess to...
Okay, give us just a minute here.
Okay.
We're going to close the public hearing. And I do have these comments. We have two highly respected attorneys that have look at the same information and come up with different conclusions. Got a very highly respected citizens who are bringing their information to us. And I do respect all of this and the county commissioner out there. But I doubt very seriously if the Board of Zoning Appeals has the authority to overrule the Planning Commission. The Planning Commission can take this up anytime that they want to, provided the commissioner out there that represents the area can get them to do that. So that, and I'm not sure about this. I suspect most of everything that's been brought up here tonight is going to be in the courts, and the courts are going to make a final decision on that. But the board will give you a decision one way or the other. We're going to take about a 5-minute recess, if that's okay with everybody, and then we'll come back and give you some kind of indication from the board on what direction that we will take on it. Thank you so much for the information you shared. Zoning appeals back to order. Our recording secretary is not back yet. We'll wait just a minute for her. Okay, we're back in order now. Terry, are you ready? Okay. We're at a point now that we've had a lot of information thrown to us. And I agree, it's a very complicated issue. And it's probably one of the most difficult issues that we'll have in some time. All of the years that I've been on the BZA since this stint, since 1982, I don't recall that we've ever been asked to overrule a planning commission decision. So it's the first time, I guess, for everyone. I would like for the county attorney to give us his opinion on where we are at this time. And for those of you who need to ask him questions, be ready for that.
Thank you, Mr. Chairman. Our office understands that there are 3 issues that have been appealed. One being that the site plan approval at the Planning Commission meeting back in December of last year, that's the first issue for appeal. The second, Mr. DeMassi's, and I'm quoting from the document filled out by Mr. Jackson, the determination that Rogers Group activities on this property are non-conforming, and the last issue on appeal being Mr. Jones's decision to not punish Rogers Group and Jenny Justice for violating the zoning ordinance. With respect to the site plan approval, well, with respect to all these appeals, we understand they're appealed under Section 10 of the Rutherford County zoning resolution that was applicable at that time, which says that the Board of Appeals shall have the authority to hear and decide appeals from any order, requirement, decision, or determination by any department, office, or bureau responsible for the administration of this resolution. Our office has researched the state law. Our office has researched the Rutherford County zoning resolution, and also our office has researched the Tennessee case law that interprets these types of issues. And it's our opinion that, our office's opinion, that Section 10 is inapplicable to the appeal of the site plan from the Planning Commission. And it's our office's opinion that a Board of Zoning Appeals does not have the authority to review a Planning Commission's decision, such as the one before the Board of Zoning Appeals right now. With respect to the next issue concerning Mr. DeMassi's information that was provided at the Planning Commission meeting in December of 2012, we also feel like, and it's our office's opinion, that Section 10 regarding the appeal of administrative decisions is inapplicable as well. It's our opinion that Mr. DeMassi was asked a question and he provided information in the context of a Planning Commission meeting, and that Section 10 of the applicable zoning resolution did not contemplate the type of information that Mr. DeMassi provided at the Planning Commission meeting. And lastly, with respect to the third issue regarding Mr. Jones not punishing the Rogers Group and Ms. Justice for violating the zoning ordinance, we also feel like Section 10 is inapplicable to that particular issue. So we, as it concerns all issues that are currently before the Board of Zoning Appeals, we feel like the Board of Zoning Appeals is not the proper avenue to pursue this type of action.
Any questions from the board? Joe?
I got a question. Why was it brought before us then?
It's not it's my understanding that it's not the planning department's decision to determine what should and what should not be on your docket. It was filed, it was placed on the agenda, and that's why it's before you.
I watched this December 10th meeting twice. We got a little disc. And you know, they bought the land in 2000 and they built the building. And I've actually been out to the site, and it's one heck of a hole. 400, 500, 600 feet, I don't know. It's down there. I've been out there about 2 weeks ago. I don't know what the rush is now. I'm not trying to step on anybody's toes, but I'm on this board for one reason. And that's to be as honest as I know how to be. My vote ain't for sale. My vote ain't swayed by a friend. I'm here to vote my heart. And I don't know what the rush is. I look at this as the mosque graveyard situation. They had a graveyard. You got court cases going at it, and that was pulled. And I think this tonight should be the same thing. The Rogers Group should pull this till after those court cases are over. And I hope I don't offend Doug's group, Mr. Jones' group, or either set of lawyers. But I've read most of the material, and we can't defer it. It can't be deferred but 90 days, so that'd be about February the 28th. But they built these buildings in 2006, and they weren't permitted. Why all of a sudden, before it comes to court, do they want to permit this? And it's questions in my mind about the depths and the setbacks. And we don't have a right to hear tonight, but I would like to see the Rogers Group pull this to after the court cases. And I think they would probably make their neighbors out there pretty happy if they did so. It kind of looks to me like that they want everything legal when they actually go to the courtroom. Thank you a lot.
Any other questions?
Yeah, I got a few. Mr. Chairman, I just want to make sure I'm hearing everything right from our attorney. With what they've applied for here tonight, and you gave 3 things. The site plan approval was approved by the Planning Commission, and the decision made by Mr. DeMasi about it being a non-conforming use, and then the other decision about Mr. Jones not punishing the Rogers Group for their violations. Are you saying that everything that's really they've came before us tonight, we can't even consider any of it?
That's our office's opinion. That's correct.
All right, sir. Well, with that being said, I guess I want to throw some things out. I tried to take some notes here, and I know both sides of attorneys have spoken here, and I think it's kind of some questions, and I know we're not going to hear it here tonight, but I think it's some questions, and I don't know if anybody wants to answer them or anything, but I do want to throw them out there and have them on the record. One thing I think what was said, Mr. DeMasi, can you tell me? I know this will be a question for you. This property that's out there now, this quarry, can you tell me what is the current zoning of it?
When the new zoning ordinance took effect January the 1st, it was zoned RM, or residential medium density. Prior to that, it was zoned R15, which is our residential 15,000 square foot minimum lot size.
Okay, so before our new comprehensive plan took place, it was the
new zoning ordinance.
Okay, it was just residential 15.
Yes, and the RM, the residential residential medium density, it's pretty much the equivalent of what the R15 was.
Okay. So this is still zone residential property, this quarry is?
That's correct.
Oh, my goodness. The other question, I guess, was, and I don't know if this would be for you or for Mr. Jones. The question was brought up, and I don't know what all structures are out there that they're referring to, but seems to be there's a lot of buildings and structures that have been constructed out there without permits. I'm just wondering why they weren't. I guess the question is why they. Well, I guess the question is, is that a true statement saying they haven't been permitted? And if they haven't been, I guess why?
Well, based on the discussion that was had at the Planning Commission, of course, you can ask the representatives of the quarry of Rogers Group as to why permits weren't obtained when they were first, when they should have been. But the discussion we had at the Planning Commission basically was, at this point, I think they're well aware of the fact that those kind of structures, the county does expect them to get building permits, and moving forward, I don't expect that to be an issue.
All right, sir. I don't know who this would be for, but it's just I guess it's a thought on my mind. As one of the attorneys gave us this timeline of events, which was pretty interesting. But as I read through this thing, it did seem and I know Commissioner Sandlin kind of alluded to it. He said he was on planning, may still be, it may have even been during all this time, but it seemed like that the Planning Commission did have a lot of concerns about this thing, and I don't know if they had the proper regulations in place at the time. I don't know if they were trying to be very cautious and didn't know what to do, but at any result, it went to court, and what happened. One other concern I have is, and I don't know if these will be I don't know if there's any regulations on it, but it is a concern. And it's been brought up. The question was about the depth of this quarry. I don't know if I've heard 400 feet, 600 feet. I don't know if you know what the exact depth of that is. I don't know if there's any regulations that we have in this county, or if there's any even in the state or whatever about the depth of a quarry. With that being said, I'm just wondering, when this no longer becomes a quarry and you got, I don't know what the whole total acreage of this property is, and you got something that's 400, 500, 600 feet deep, what's going to become of this property? Well,
typically with those quarrying situations, the state does require a reclamation plan. Again, that's something that Rogers Group can probably speak better to than myself, but there are requirements that the state has for reclamation of quarried areas.
When you say reclamation, you're talking about. Can you elaborate on what that definite?
Just basically, what are they going to do when they're done? Essentially, is what that is. Now, are they going to refill the hole? Again, those are questions you probably have to ask them. So yeah, it's good size. There's no doubt about that. But there are state requirements that they do have to abide by for that.
Okay. Do you know if the Rogers Group or Stoneman has that in place? What they're going to do with that?
I imagine that anything that, again, if it's a state requirement, that they would have to have. It's not something we would necessarily look at. I'd have to look at our new regulations and everything and determine anything going forward what that would be. But
I understand what you're saying. It being regulated by the state, and we don't know if they have that plan. But I guess my concern is I don't live out there, but the state may regulate it. But this is in Rutherford County, and it's something we're gonna have to deal with. And those folks out there are. Let me ask you this, and this is probably not. I guess I'm trying to relate it to when we do. I know on Board of Zoning we approve borrow pits and stuff like that. As a county, do we have anything as far as a regulation on how deep you can dig? And I know this is dirt versus rock, but I'm still just trying to see if we have anything in there. And I'm not trying to put you on the spot. I'm just trying to.
You're fine. I just give me a second to flip over to the section. I don't think necessarily on anything on depth. We a couple years ago passed some requirements for borrow pits, and actually I'm not in the right section. It's over here. There we go. Let's see. There's nothing on that specifically mentions depth. No, sir.
All right, sir. Well, I just, but and with that being said, I know when we borrow pits and stuff like that, or we do usually have the in place with what after they take the dirt out or whatever. We do have something. They have to submit a plan what they're going to do and put back in place, or whether they're going to refill it back. If they're taking out dirt, going to refill it with rock or whatever they're going to do. But we do have something in our regulations concerning that. Correct? Okay. That's all I have now, Mr. Chairman. Thank you.
Thank you. Michael.
Chairman, I have 2 questions for our attorney. There is current court cases, current litigation going on between the county and the plaintiffs in this case, I guess. Is that correct?
I am not the attorney in our office that's involved in that case. Mr. McCreary is.
Right.
As far as the particular parties, I can't recall. Mr. DeMasi may be better to answer this than I am, but I do not know if the county is a party to either one of the lawsuits. But I'll let Mr. DeMasi answer that. But I know there's current litigation.
I guess the short answer is yes, there are. There's 2 different cases. I believe Mr. Jackson referred to those a little earlier. The first case, without going just a whole lot of detail, went back to the expansion that the Rogers Group was wanting to do and the zoning of the property. We asked the judge to make a declaratory judgment on that. The other issue, I believe, was filed by some of the parties out there against Mr. Jones and the Rogers Group. So I guess we are a party to that, although maybe not the primary party. We are a party to that. Okay.
The second question is with the county attorney's office opinion or interpretation that this board does not have the authority to address any of these 3 items that have been brought up, and the fact, and most importantly, I guess, the fact that there is current litigation with the county, should we even be further discussing any of these 3 items? Should we stop that discussion and move on to decide what we're going to do with this, whether to kick it back to the Planning Commission or whatever? I'm just a little concerned with court cases going on, and we've already determined that we don't have the authority to make any of these decisions. Why are we even discussing it, especially with current litigation going on, I guess is...
Well, just to make sure there's no misunderstanding, I don't think anybody's made a determination yet that the Board of Zoning Appeals is not supposed to be hearing this right now. But it's on the agenda because of the appeal from the Rogers Group. I apologize, the property owners, not the Rogers Group, but that's the reason it's on the agenda tonight, if that answers your question.
Tommy, you just lost me then. You saying there hadn't been a decision made where we can reverse this?
That's right, it hasn't been voted on.
I'm still not on the level playing field here.
What I'm telling you is that...
can I reverse this decision tonight? Can I make a motion to that? Because I would make that motion to reverse this decision.
If you can make...
I think it should not be heard. I think we should not do anything here tonight. And I don't know whether they should be punished, but Mr. Jones, obviously, I don't have any problem with that whatsoever. And if it was just the buildings here tonight, I probably wouldn't have any problem with that. But I have a problem tonight with the site plan. I do have a problem myself with that. Because I've been to that site out there, and you talking about a hole. I can assure you, Mr. Mossy, they're not going to fill that hole back in. Unless they do it with garbage over the next 25, 30 years. Because it's one huge hole. I've never seen a rock quarry that deep and that large, and I've seen several in my lifetime.
To answer your...
Can I make a motion tonight to reverse the decision that they made December the 10th? Because if I can, I will make it. I may not get a second. I will make it.
Joe, to answer your question, anyone can appeal any item to this board. Now, the question is whether we want to, whether we have the authority to deal with that appeal or not. And the people are here, and we have an obligation to hear all of what they have to say. And that's why we're doing that tonight. There's no reason why it can't be discussed, and there's no reason why these folks can't be heard. even though they had a chance to go to the Planning Commission. The really question I have is whether we have the authority to overrule the Planning Commission. That's what it gets down to. Now, if the board sees differently, you can make a motion. You can. Well, let's wait just a minute. Let's finish our discussions before we start making the motions, okay? Anyone else? Michael, did that answer your questions? Okay. Jerry, do you have some questions? Jerry, did you have any question or discussion? Okay.
I just want to follow up one with our attorney here, and you're not trying to put him on the spot. By what you said a while ago, I guess anybody can make any motion here they want to, but in your opinion, in your legal opinion, I don't want to misquote you. In your opinion, you don't think that this body has the authority to overrule a planning commission's decision?
I don't think this body has the authority to hear an appeal from a planning commission decision.
Thank you very much.
I got one other question. I'm still not. Can I make the motion to reverse it tonight? Can I make that motion?
You can make any motion that you deem appropriate.
Thank you.
Jerry?
Are you prepared for a motion, Mr. Chairman?
Yes, go ahead.
Prepared to make one.
Wait just a minute,
I think I brought it up first.
Jerry was online. I'm sorry.
Okay.
Go ahead.
Mr. Chairman, I would make the motion based on our attorney's advice that we take no action tonight and on the matter of the appeal for the the Planning Commission's decision.
Do we have a second to that motion?
I'll second that motion.
Okay, we have a second to the motion. Now, is there any further discussion or comments? Call the roll, please.
Mr. Chairman, before we call the roll, I want to clarify the motion. Mr. Sartain's motion, if I understand it correctly, is for the Board of Zoning Appeals to not review the Planning Commission's decision, to not review the information that Mr. DeMasi provided to the Planning Commission, and to not review the third part of the appeal concerning instruction concerning Mr. Jones to punish the property owners. Is that correct?
That's the way I'm interpreting his, and you may correct me. Is that?
That is correct.
Okay. Okay, and we have a second on that. Now we're all clear. Okay. Call the roll, please.
Keith Bratcher?
Yes.
Joe Crowell?
I got one thing to say. I would like to see the Rogers Group pull this like the mosque graveyard
Vote yes
did.
or no, please.
Let me say that one statement, and I will.
But how did you vote?
Okay.
Joe, did you vote?
Yes.
Okay.
Sartain?
Yes.
Jared Barrett?
Yes.
Dane Cantrell?
Yes.
Motion carries.
The next item of business, thank you. Those of you who may need to leave, go ahead and ease out, but we've got some more business to handle. The next item of business, we have been requested by the Rutherford County Planning and Engineering Department to active classifications for gun ranges and C&D debris landfill. So what do you have on that, please?
Yes, Mr. Chairman, thank you. Under the new zoning ordinance, land uses are classified into a number of specifically defined types, or what we call activity classifications. They're based on common functional characteristics or compatibility with other uses. And as an example, which is in your staff comments, uses such as department stores, hardware stores, those kind of things are defined as general retail trade uses. Appendix C of the new ordinance, Land Use Index, lists a number of uses in their activity classifications. From time to time, a use may be proposed that may not be included in that list. And based on that, there's a section in the new ordinance, Section 201, that states, when there is a question concerning the appropriate activity classification for any use not listed herein, the Board of Zoning Appeals shall make the determination based upon the characteristics of the unlisted use. and we've become aware of a couple of uses that we want to bring to your attention tonight. The first is a construction and demolition C&D landfill. C&D landfills typically accept construction, demolition debris such as roof shingles, concrete, wood, things of those natures, but do not accept items such as household garbage, food, those type of things. They're classified as Class 4 landfills according to the Tennessee Department of Environment and Conservation, and the operation of facilities is also by TDEC. The most similar land use that we have in the ordinance currently is a sanitary landfill. While they're similar, sanitary landfills accept a larger range of materials, including household garbages, food wastes, and sanitary landfills are also defined as extensive impact facilities. But different from other uses in the extensive impact facilities category, they're only permitted by special exception in the heavy industrial zone. And we do list some specific standards that we have for extensive impact facilities, which you have in the handout, which I won't go into. Basically, what we're recommending for the C&D landfill is that they also be categorized as extensive impact facilities. And you'll have a handout of the Appendix B, which is the chart in our zoning ordinance, as well as Appendix C, which is the land use index. If they are categorized as extensive impact facilities, this would allow them to be by special exception in the commercial general, which is our most, our least restrictive commercial zone, as well as the light industrial uses, light industrial zone, and also by right in the heavy industrial zone. The second use that we have are just gun ranges. And gun ranges, either indoor or outdoor, of course, they provide opportunity for various sporting, skeet shooting, target practice, those kind of things. The most similar land use we really have in our ordinance currently is a paintball field, which are classified as entertainment and amusement services. They're slightly similar, however, gun ranges involve participants shooting at stationary targets or skeet strap, using, of course, more powerful guns most of the time. So there's a potential for more noise, and the possibility also is out there for greater danger possibly because of skeet shooting and those kind of things. So what we're recommending for gun ranges is that what we're going to do as staff is come up with some amendments to the zoning ordinance that deal specifically with outdoor gun ranges. However, I think we feel comfortable with saying indoor gun ranges can be classified as entertainment and amusement services. That would fall under some of the existing classification that we already have. Again, what we're probably going to do for the outdoors, come up with a new classification, probably break down entertainment and amusement services to be either indoor or outdoor, and there's a few other uses that we'll probably lump into the outdoor category as well. So our recommendation for the C&D landfill is that they be classified as extensive impact facilities, and then that indoor gun ranges be classified as entertainment and amusement services.
Do we have any C&D landfills in the county now?
Well, the county, I believe, operates one near the landfill up there at Jefferson Pike. I know of that one, and I'm not sure. I think LoJack may have a permit to do some on New Nashville Highway, it seems, but that's been in existence for prior to this taking effect.
Jerry,
I just got a question for Doug. I recollect that a great deal of just normal gun sales stores in Middle Tennessee and different areas also have a range in the basement, for instance. Would this zoning prohibit those two from being at the same place? Say, if a guy had on Broad down here had a gun store and he had a basement, could he have a gun range in the basement?
Well,
it's quite a common thing to have together.
Yeah, right. And currently, you might be able to argue that's an accessory use to that. Currently, we do have a section in here, in Appendix C, I believe gun sales are actually gun shops, gunsmith shops. Our gun shops are classified as general retail trade. While there's not specific provisions in here regarding shooting ranges, you might be able to argue it's an accessory use. However, if you have this category in there, I think it really solves that issue. I don't think that becomes an issue after that.
Joe?
I have a question, Doug. Where does all the shingles, roofing shingles go now? You roof after roof?
Probably, yeah, just the regular landfill.
Oh, they go to
probably. Or, some of them may go to the county's landfill. I'm not sure what goes where exactly, but,
Mr. Jones?
Landfill is a construction debris landfill.
Say that again.
County landfill accepts construction debris.
Okay. Yeah. Any other questions? Okay, do we have a motion on his recommendation?
Make a motion we approve.
Okay, we have a motion that be approved, your recommendations. Have a second.
Second.
Wait a minute, I missed the motion. Who was that? Second.
Call the roll, please.
Bratcher?
Yes.
Jim Kroll?
Yes.
Jared Payne?
Yes.
Jared Barrett?
Yes.
Yes. Thank you so much for a good meeting today. All of you had very pertinent questions, and it's a very tedious type of decisions to make. You did a great job. You are adjourned.